welcome everyone. My name is Dr. Kevin Stewart. I'm Executive Director of the Austin Institute for the Study of Family and Culture. And I'd like to welcome you to the third debate in the Diana Davis Spencer debate series. This series has been made possible with the generous support of the Diana Davis Spencer Foundation and is a partnership between the Austin Institute and the Intercollegiate Studies Institute, or ISI. The goal of this debate series is to promote the proper exercise of free speech and to provide a model of civil discourse and debate that will help us address the important issues of today. The topic of today's debate will be the Supreme Court. The Supreme Court is at the center of American politics today, especially in the wake of the Amy Coney Barrett confirmation and the beginning of the Biden administration. Many proposals have been made to reform the court, and many of those have included some fundamental restructuring. The Constitution specifies that there will be a judicial branch, but gives broad powers to Congress regarding the size and shape and even scope of the judiciary. So today, we have brought two of the top legal minds in the country together to debate whether or not restructuring the Supreme Court is a good idea, and if so, in what ways. So now I'd like to introduce our two debaters this evening and then explain the format that we'll go through tonight. First, Daniel Epps, who teaches law at Washington University in St. Louis, is a nationally recognized expert on the Supreme Court and constitutional law. An experienced Supreme Court litigator, he most recently served as co-counsel for the defendant in Ocasio versus United States, 2016, which addressed the scope of criminal conspiracy liability for public sector extortion. In 2019, Democratic presidential candidate Pete Buttigieg brought new attention to court packing plans when he put forward a proposal based on a Yale Law Journal article that Professor Epps co-authored. Epps has also written for the Harvard Law Review, the Michigan Law Review, and the NYU Law Review, as well as for the New York Times, the Washington Post, Vox, and the Atlantic. Professor Epps has clerked for Supreme Court Justice Anthony M. Kennedy and served as an appellate specialist at King and Spalding LLP in Washington, D.C. He received an A.B. summa cum laude from Duke University and his J.D. magna cum laude from the Harvard Law School. Welcome, Professor Epps.
Thanks for having me, Dr. Stewart. This is great. I'm really happy to be here with my friend, Ilya Shapiro. And I just want to make one request at the beginning. I'm a law professor where we grade classes on a curve. And I just want everyone to recognize that Ilya is the master of these debates. He's probably done 100, 200, 300 or more. And this is only my second such debate. So I'm hoping I can be graded on a curve.
All right. Well, I'd better introduce him. So I'm not sure
managed expectations executed.
I'm not sure I can do better than the introduction we just heard, but Ilya Shapiro is the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute and publisher of the Cato Supreme Court Review. Before joining Cato, he was a special assistant advisor to the multinational force in Iraq on rule of law issues. He also clerked for Judge E. Grady Jolly of the U.S. Supreme Court, or the U.S. Court of Appeals for the Fifth Circuit, and practiced law at Patton Boggs and Cleary Gottlieb. In 2015, National Law Journal named him to its 40 under 40 list of rising stars. A much sought-after legal commentator, Shapiro has testified before Congress and state legislatures, has filed more than 400 amicus curiae or friend of the court briefs in the U.S. Supreme Court, and has written for the Wall Street Journal, the Harvard Journal of Law and Public Policy, the Washington Post, the Los Angeles Times, USA Today, National Review, Newsweek, and many other publications. He is the author of Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court in 2020, co-author of Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act and the Constitution, 2014, and editor of 11 volumes of the Cato Supreme Court Review, 2008 through 2018. Shapiro holds an A.B. from Princeton University, where he became an ISI Honors Scholar, an MSc from the London School of Economics, and a J.D. from the University of Chicago Law School. Welcome, Mr. Shapiro.
Thanks very much. And I think we have one other connection, Dan and I. He didn't, for some reason, he isn't listed on his official bio, but I published him as editor of the Cato Supreme Court Review. So that clearly is what led to his stellar academic career.
And I worked on at least one of those 400 amicus briefs with you too. I don't know if you remember back when I was in practice.
There we go. Well, now for the plan for tonight. First, Mr. Shapiro and Professor Epps will offer opening statements, which will be followed by some questions from me. Then some of the students watching will be able to pose their own questions, and also other people can put questions in the Q&A section there on the website before we wrap up with some closing remarks from our guests. So right now, we'll begin with our guests' opening statements. Professor Epps, you're up first.
Great. Okay. The Supreme Court has not worked perfectly over in American history. But on balance, I think it's hard to say that over the long run, it's been a failed institution. The Supreme Court has done a lot to advance our democracy. Nonetheless, I'm going to argue that we should pursue some kind of major structural reform to the Supreme Court. And I want to try to explain why. What I see is that there are some major problems with the way the court currently operates and with the kind of structure of the court's membership that are becoming apparent. These problems have not as apparent for a long time, but when you combine them with certain recent trends, the design of the court is really starting to wear at the seams. And so let me go through those. So first of all, life tenure. The Constitution specifies that justices hold their office during good behavior. That has been interpreted to mean life tenure with no retirement age. This is unusual both in the United States, where only one of the 50 states has life tenure for judges with no mandatory retirement age, and globally, where it's extremely unusual to have a high court without either a retirement age or fixed terms. What this means is that justices can serve until death, or they can choose to strategically retire based on who the president is. And what we're seeing is justices are living a lot longer than they did a couple hundred years ago, and tenures have started to increase in the last half century or so. Two, the Supreme Court size. It's not set in the Constitution, but it has been set at 9 for more than 150 years. It's relatively small. Many countries have much larger court. Third thing, and these are all going to combine at the end, the court decides a lot of really important questions. This wasn't always true for the first part of American history. Judicial review, that is the power of the court to strike down legislation as unconstitutional, was not as widely used, and especially so for federal legislation. Now it is much more regularly used. And we ask the court to resolve some of the questions that most divide us as a country. Abortion, whether, the legality of Obamacare, any number of things that you can name. They're, not everything, but some of the biggest hot button issues come before the court. And they're deciding these really important questions. We then have this increasingly polarized legal culture, which tracks party lines more and more. That's relatively unique and new in American history, where we have party affiliation really determining ideology. That hasn't always been true. So you combine all these things together: life tenure, small size, vacancy turning on strategic retirement or unpredictable deaths. And we have these really huge swings where the kind of consequences for policy, for law, really depend on kind of unpredictable random events in ways that don't perfectly track democracy at all. So as one example, Republicans have appointed the last 15 out of 19 justices to the court. That's since 1968, even though Democrats have held the presidency for 20 of those 52 years. Okay, why does that matter? Well, we want the court to have legitimacy. We want it to be able to resolve controversies in a way that the country can live with, even if people don't agree with its decisions. And a big part of that is a perception of fairness, that the court is doing something other than politics, that its membership was chosen in a fair way. Yeah, maybe I don't like every justice, but I can sort of understand why it works that way. But what we've seen recently is a serious escalation of the politics of judicial nomination and a serious degradation of norms. And that's led to an increasingly large slice of the country start saying, given the way the court is selected, given that it's kind of so random, just turns on who has the Senate win, when somebody dies, strategic retirement, why should we let these 9 folks decide things for us? And that, I think, explains why we're starting to see Democrats willing to embrace these once kind of unthinkable proposals, like expanding the court, that was just thought of as a political third rail until very recently. Now, I hope to convince you that the problem here isn't just about partisan advantage. It's actually a structural problem. And if the shoe were on the other foot, I think we'd see something that looks very similar. And I'm not going to get into the solutions yet, but I think that the best solution is some kind of arrangement that doesn't make the court's membership swing so much on the results of particular elections and swing so much on the basis of random and unpredictable events. There's different ways to do that. One thing that Democrats have thought about is just straightforward court packing, adding seats. There's cases for and against that. I have sought to identify other solutions that we can talk about a little bit more in the Q&A that I think have less sort of partisan valence to them. And at the very least, I just want you to consider the possibility that this kind of structural reform is necessary, putting aside the specifics of what the reform should be.
All right. Thank you, Professor Epps, for those opening remarks, and a good job setting the table there. And now it'll be Mr. Shapiro's turn to open his side of the argument.
Sure. Thanks again for having me. And I was expecting to respond to Dan's actual proposals. So I'm going to be on the fly a little bit here. His balanced court and his Supreme Court lottery, for which he's rightly been hailed as one of the most creative thinkers on Supreme Court reforms. But really, this is a debate on court packing. So, I guess term limits are part of that. I've written on that plenty. I kind of give 1.5 or 2 cheers for court packing. I'm amenable to it. It'll solve the issue of kind of arbitrary vacancies and politically timed retirements and morbid health watches over octogenarian justices, but it won't change, the politicization, quote unquote, or the court ruling in ways that people don't like and see as illegitimate because they're tied to all these things that at least progressives lately have been complaining about. So yeah, it'll solve some of perception issues, but it doesn't go to the root of the matter of what people generally identify when they say the court's illegitimate or needs structural reform or what have you. And indeed, the last few years have seen an explosion of creative court reform proposals to respond to unpopular decisions. On the extremes are calls for retention elections, as Ted Cruz proposed after the 2015 rulings on Obamacare and same-sex marriage, and even abolishing the Supreme Court altogether, as Harvard law professor Mark Tushnet suggested after Justice Kavanaugh's confirmation. And this phenomenon has accelerated with progressives' frustration at Donald Trump's win in 2016 unexpectedly, that 2, vindicated Republicans' risky strategy of not acting on the Merrick Garland nomination, and 3, pushed through the Amy Coney Barrett nomination right before the 2020 election. Now, even before Trump, progressives complained vociferously about Citizens United, Shelby County, partisan gerrymandering, examples of structural advantages enjoyed by corporate interests, conservatives, and Republicans, all the same bogeyman. Once Trump took office, all that was dialed up to 12, even as Hillary Clinton handily outspent the Trump campaign, and the House of Congress that Democrats have been unable to take back is the non-gerrymanderable Senate. The activist group Pack the Court said about 2 years ago, March 2019, said, quote, because the court has undermined the institutions of democracy, court packing is the only way to restore the integrity of the political system. To be taken seriously, presidential candidates must explain how they'll restore democracy over the objections of a hostile and partisan court. And they did, if you watch the 2020 primaries. As with most such proposals in our history, the partisan appeal is both evident and heavy-handed. But if Democrats think they'd be reuniting the country with court packing or structural change, then they deserve the political losses that such ends justify the means radicalism would inevitably cause. And if they think that packing the court would restore norms, then they really don't understand the nature of governance. Just as 2 wrongs don't make a right, you don't restore norms by transforming institutions, particularly in doing so would mean eliminating the legislative filibuster, which would open up another can of worms. Now, recognizing that expanding the court wouldn't depoliticize it, just pure packing, Dan, as I've said, as you've just seen, has led the charge in outside-the-box thinking. But with respect, Dan, these ideas are too clever by half. For one thing, your Supreme Court lottery, where lower court judges are just randomly assigned to serve on the Supreme Court for a few years, that would likely shift the deference due pre versus post lottery decisions. Panels wouldn't apply much weight to a case decided just the previous year by a randomly assigned panel, which would thus require several rulings going in one direction for a legal issue to be as settled as current precedents. Of course, that may be a feature, not a bug. But is the chance for better decisions, such as it would be, worth the trade-off in lost finality and stability in the law? Citing statistics showing that circuit judges give less weight to the opinions of justices who have left the bench and that short time horizons hurt cooperation, Duke law professor Stephen Sachs suggests in critiquing Dan's proposal that short-term appointments would create a, I love this phrase, quote, judicial goat rodeo of wildly fluctuating law. And you know, by the way, who else made a similar suggestion? The circuit judges taking temporary assignments on the high court. One Josh Hawley, arguing in National Affairs, I think 8 years ago, that justices would one day return to the circuit court, may be more circumspect about altering constitutional rules. Sachs points out that this, quote, ephemeral tenure might instead encourage justices to get their licks in while they can. And then there are atmospheric issues. A Supreme Court lottery limited to circuit judges would exclude potential justices from other legal walks of life. No state jurists, executive branch officials, senators, professors, or anyone else. And finally, if the goal is to depoliticize confirmations, then raising the stakes on lower court nominees hardly helps. Most of President Trump's circuit judges were confirmed with less than 60 votes, many after wild accusations involving collegiate writings, tweets, and other smears. Making them all into justices in waiting, even more than some already are, will not improve that situation. As for the balanced court, where you have 5 Republican justices, so-called, 5 Democrat, and 5 that have to be unanimously selected by the other 10, how would one even determine whether a judge is an R or a D? Why not switch parties to maximize chance of selection? Would it even be constitutional to exclude members of third parties or independents? A Republican dying during a Democratic presidency could lead to a Souter or a Stevens, or at the very least, someone who wouldn't be picked by a president of his own nominal party. Now, Dan's idea that the Senate leader opposed to the president could provide a list of choices is a plain violation of the Appointments Clause, which gives the president the sole power to nominate judges of the Supreme Court. So we're talking a constitutional amendment, which is basically impossible. Moreover, while some high-profile cases are split ideologically, many are not. For example, any criminal defendant would prefer that his case be decided by a Gorsuch or a Sotomayor rather than a Alito or a Breyer. This plan values public acceptance through perceived moderation over correct legal conclusions. But the biggest problem with the proposal is that in the name of depolitization, it would affix scarlet partisan letters to 2/3 of the justices, making the court appear as a mini legislature all the more. So in conclusion of, at the end of the beginning, underlying both the judicial lottery and the balanced court proposals is a problem with the proponent's premise that the court needs saving in the first place. I argue that the court isn't in crisis at all, but liberals and especially legal elites who have relied on it to solve social ills they can't remedy at the ballot box are very unhappy with its nascent conservative majority. But the court is more popular and by most measures most legitimate than other government institutions. It ain't broke, so don't fix it.
All right, thank you both. I think we'll proceed now to Q&A. So I will start some questions just to kind of guide your interaction. It should be very little of me and a lot of the two of you. But I think it's an important point to pick up right where Mr. Shapiro ended, which is there a problem at all? Does the fact that, I was thinking of it in my own head, I was going to play devil's advocate, but Ilya beat me to it in saying every summer, every June, we wait with bated breath as a country for the final decisions of the court to be rolled out. Usually their most controversial or spectacular decisions. But doesn't that in and of itself signal that something's going very right? Because we all wait and have great admiration for or great respect for kind of what's going on here. We wait for these opinions.
So is that for me?
Yeah, sure. You can start.
So we do all wait for them, although I think some people are waiting because they're afraid of what the court is going to do. And the fact that, we recognize that they have power doesn't necessarily mean that we think it's a great system and that we think there's no problem there. I guess the point I really want to make is it's hard to say there's not something deeply amiss. If you think about a world in which one of the two major presidential candidates who was elected president was not even willing to disavow court packing. And you can just say, well, that's liberals being liberals. But something that strikes me as the very fact that we're now in that situation suggests that something is fundamentally different, and something that's happened is fundamentally different than what has been happening before. My thesis is that what's fundamentally different is the phenomena I'm talking about, the increasing polarization of law. And I don't think you can escape that problem by just saying, well, our side is right on the legal issues, so therefore there's no problem here. Because what we need to recognize is that the country is really, really divided right now. And that translates not just to politics, but to law as well. And with that being the case, I'm just not confident that the center can hold. The court, remains a somewhat popular institution. It's taken a little bit of a beating, especially with the Kavanaugh nomination. But what's going to happen, I think, is going to really determine how much of a legitimacy crisis the court faces. If the court ends up deciding cases in a way that the country sort of is on balance happy with, the crisis that I'm predicting is not going to come to pass. But that might. I think there's reason to suspect that might not happen.
So I'm going to give kind of a summary of my book, Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court, which you can buy. And if you buy, I'm happy to send you a signed book plate since we can't do in-person signing these days. Because a lot of what Dan said just now, not the structural reforms, but what he said just now is correct. We do have a problem. We have polarization. We have, two countries in many ways, clashes of values. But you have to look bigger, Dan. That problem is not centered in the court or the judiciary or judicial confirmations. It's centered in the country at large. We're kind of at the culmination of several dynamics where you have divergent interpretive theories mapping onto partisan preferences at a time when the parties are more ideologically sorted and polarized themselves since at least the Civil War. And so whenever there's a vacancy in this, precious vacancy in this powerful institution, of course, you're going to have a fraught process. The politicians are responding to the incentives that they face. And so the ultimate solution is not figuring out, what the term limit should be or what the exact structure should be. Should it be 15 or 19 or how balanced or this or that? That's rearranging deck chairs on the Titanic. It addresses symptoms and doesn't even address those symptoms very well, because fundamentally the problem is the centralization of power in Washington and at the federal government, and within the federal government skewing towards the executive branch, with Congress punting its responsibilities to a branch that can't be unelected. It can only be sued. So those things get decided in the courts as well. So I have no easy overnight solutions. It's not simply, my side is getting, I don't even know what, I'm a classical liberal. And I disagree with lots of people on different things. The 5 or the 6 Republican appointees disagree amongst themselves much more than anyway. But it took us decades to get to where we are. And it'll take us decades to recover. But it does mean kind of a broader discussion of the court rebalancing our order, so Washington's not making all these big decisions and all these major controversies every June. That is the kind of a one-size-fits-all solution for this large, pluralistic, diverse country.
Well, I want to hit a note of political science while we're in here. So while we're on this topic, it seemed like Daniel's beginning to suggest that Gerald Rosenberg's book from, 91, I think, The Hollow Hope, which theorizes that the court, in fact, even when it appears out front, is always actually following public opinion, that they're late. The court tends to be late to the game. It sounds like you're at least implying, if not outright suggesting, that if it was true, it isn't anymore. Do you think something has fundamentally changed since 91?
So I think I think that's a really important work. And I'm sort of a student and mentee of Professor Michael Klarman at Harvard, who sort of carries on the Rosenberg thesis in arguing that, courts really are maybe kind of leading from behind more than we really think they are. And so I do think that as a descriptive account of what's happened historically, that has been true. The court is a little afraid of getting out over its skis. There's been a lot of moments if you go back decades, where people are like, okay, this is the moment the court is going to do all this extreme stuff. And then the court ends up moderating, hewing more to public opinion than we think. And I think that could still happen. I think one reason to think that might be less likely to happen is now the court is divided 6-3 rather than 5-4 on, either you could put it as partisan or ideological lines. And so, we've gone through a long period where the court was kind of 5 conservatives, 4 liberals. And at that point, you kind of just need one person to kind of go against the grain in any one case, and the court does something surprising, and that you end up with a court that's kind of, handing out decisions that each side of the country, they like some, don't like another. And I think Chief Justice Roberts, I don't want to get into his head too much, but it does, a lot of people think that it's hard to explain some of his jurisprudence without some sense of what's going on politically. With the move, though, in the court where Chief Justice Roberts is not at the center, now the median justice is maybe Justice Kavanaugh, maybe Justice Gorsuch, hard to know. And the rise of a certain, original schools of legal interpretation, which have sort of more sort of fixed methodology, we might see the court be less willing to kind of engage in flexible decision making that hews more to public opinion. That could be a good thing, that could be a bad thing, but I do think that is something that we could see happen, and that may have some political consequences down the road for how the court is perceived.
Ilya, do you want to respond to that?
Yeah, I mean, I went to University of Chicago Law School, so I'm not unfamiliar with Professor Rosenberg. In fact, I think he commented the last time or the second last time I spoke there on a talk I gave. I think the court isn't always leading from behind. Sometimes it actually is leading, but historically, it never gets too far ahead or behind public opinion. There is kind of that Overton window, if you will, of kind of permissible or what the court self-perceives to be legitimate outcomes. Perhaps for John Roberts, that's narrower. Perhaps for others, that's wider. I wrote a cover story for the Washington Examiner magazine last summer called Roberts Rules, trying to explain exactly what he's doing. I think in the illustration, they have him perched on a weather vane or something, but it's not quite that. He's not like an Anthony Kennedy moderate, switching which way depending on the area of law or something like that. He's more acting as a JV politician, trying to gauge the political impact of decisions and things like that. So we'll see. It's a 6-3 court, sort of, depending on the area of law. What will Roberts do now that he's no longer the median vote? We'll see this June. I think this whole discussion, if we were having this debate 8 months from now, there's a chance it might go differently if the court either decides a whole bunch of controversial blockbusters or decides a bunch of nothing burgers, or it could muddle along. But it's yet to be seen whether the court really is getting out ahead of its skis or trailing opinion, being retrograde or something.
You've both noted that the court in general, and perhaps Chief Justice Roberts in particular, always seem to be aware of the Federalists' counsel that the court has neither the power of the sword nor the purse, that essentially its authority comes from its prestige. And there's a lot out there kind of trying to see Roberts' actions in particular through that lens of safeguarding the institutional prestige of the court. And so with that in mind, the question to both of you, and you can take it, whoever wants to go first can go first. What are the costs, the potential costs of reform or the potential costs of not reforming, right? So in either way, it looks like there could be costs and benefits to be worked out here. And I'm wondering what you foresee as the costs associated with reform attempts and also the costs associated with not reforming.
So okay, go ahead, Ilya.
Either way, in our polarized time, you're going to have, half the people upset, whatever you do. Biden said he's going to have this judicial reform commission. Perhaps that's a blue ribbon commission is typically what a politician does when he wants to kick the can down the road. And Biden clearly hoping that the Supreme Court doesn't create too much controversy, because when his commission, if it's formed, releases its findings in July, nobody cares, right? The costs, but if there are real problems of legitimacy or what have you, then not reforming will deepen that, and maybe at that point, respect for the Supreme Court will start diving to the level of where respect for Congress or the executive or all other institutions, save, local government, although that's taken a dive during COVID as well. I guess small business, respect institutions generally. We're at a level of historic low level of social mistrust. So that's unfortunate for all of us. Oh, and on that question of legitimacy, one more point. I took a look at this. This is one of the chapters in my book, and I think that the court is least legitimate and is perceived as least legitimate when it tries to take legitimacy into account. That is, when people see judges acting not as judges, but trying to make some sort of political compromise, wheel or deal, make decisions not based on the law. They don't like that. They can see, even if they disagree with the judgment, often they'll say, okay, I don't like that. We need a different kind of judge. But if they see some sort of, Roberts with Obamacare, kind of transforming everything, ruling in a way that's completely head scratching, that detracts from legitimacy.
Daniel?
Yeah. I think that Ilya's right that to the extent the court is seen as sort of nakedly political, that can hurt legitimacy. And there's also kind of a deeper question here, which is, people care about the substantive decisions, but sometimes the substantive decisions don't actually line up with the sort of what we think of as kind of legally legitimate. And, one example of that is the Obergefell decision establishing a right to gay marriage. That's an opinion that's sort of gotten sort of progressively more popular as public opinion has moved more in support of gay marriage. As a legal opinion, I think it's hard to say it's a masterwork of craft. It's sort of hard to say, it's this, great opinion in terms of how it sort of crafts the doctrine and so forth. But it's popular because people like the outcome. And I don't know the extent to which the public is really aware of justices engaging in this strategery, as you might put it. I do think that there was a lot of criticism of Roberts. He was perceived as engaged in kind of those kind of political considerations with the Obamacare case. And I think that, that is a legitimate inference from what happened. It's not the only inference one can draw. But I think that he maybe, his thought process was, if we take away, past this and end up, really affecting a bunch of people's healthcare, it's going to cost us too much down the road. And, one thing that we saw was, with the Barrett nomination, Democrats clearly thought they were on the winning side of the healthcare issue by that point, that they were sort of framing the whole debate about this is about taking away healthcare. And that's, we had the recent case involving that in the court. People don't think it's likely to end up overturning the Affordable Care Act. But just back to the original question about costs and benefits. I think the costs can be quite significant. Any change, we don't know how it's going to play out. We don't know what the next step is going to be. Part of that is why I've tried to identify in, the balanced bench and the Supreme Court lottery kind of plausibly fair reforms that don't kind of equally permanently advantage one side, that are just kind of like fair compromises, because something that's just sort of straightforward court packing, it's hard to imagine how that doesn't create a cascade, right? Then we have the other side pack back and we go back and forth like that. But if we don't, my view has been for a while that this system is really kind of creaking at the seams. And when we wrote that article, we wrote it shortly after the retirement of Justice Kennedy, sort of in the midst of the Kavanaugh, the How to Save the Supreme Court Yale Law Journal article, midst of the Kavanaugh confirmation, and published about a year later. And even when it came out, people thought we were crazy. They're like, "What are you talking about?" And to use this idea of an Overton window that Ilya put out there, that shifted a huge amount in a really short amount of time. And I think there's reason to worry that unless we figure out some way to kind of make peace on this issue across the country, that's going to keep shifting, and we're going to see, challenges to the court's authority like we haven't seen in many, many, many decades.
Well, the thing is, I mean, I don't know. We're entering this period of where Trump got surprisingly 3 appointments in one term, and Trump being sui generis. And what does that all mean? Historically, I mean, the reason why term limits has never been that big a deal, I mean, it flared up a little bit when there was no change in the court's composition for 11 years until Rehnquist passed. Breyer was the junior justice for 11 years. But still, it gaming out like if you had the 18-year term over the previous 50 years based on who was president, who controlled the Senate, all these different things, the ideological composition of the court really should not have been different than what we'd resulted. It would have been younger, I guess, more turnover, but the balance would have been about the same. So
there would have been a Democratic majority. I've got an empirical paper I'm working on this. It would have there hasn't been a Democratic majority.
Okay, but you have Stevens, you have Souter, you have Brennan, you have like all these Republican appointees, which might as well have been, just the way that things play, the ideological balance of the court, not the partisan balance of the court. Now we might be going into a different age. I don't know. I mean, as it turns out, the Amy Coney Barrett thing really didn't matter one way or another. I think healthcare didn't matter one way or another. This turned out to be an election on Donald Trump and the pandemic, basically. So it's kind of hard to make binding social science when it's such a an outlier sort of thing. But I don't know. I mean, Dan, your proposals really are creative, and I totally give you kudos for going just beyond how many justices should we add. But like the one most salient thing, and the balance bench is really cool, but as I said, 2/3 of the justices would then have an explicit partisan letter attached to them. I mean, that can't be good.
Dan, would you take just a few minutes to lay out what those proposals are, just like thumbnails?
Absolutely, yeah. One reason I didn't do them in the intro is they can be a little bit complicated to explain. But we have 2. The first one I'll do is the balance bench. That's the one that Mayor Buttigieg ended up picking up and running with for whatever reason. And the idea here is this is kind of a power sharing arrangement, and it's modeled after civil arbitration, which is a system where you have 2 sides that disagree. A very common way that we resolve those through arbitration agreements is each side picks kind of an arbitrator that they're comfortable with, and those 2 go out and identify some third kind of neutral party. And that's considered kind of a legitimate way to resolve disputes. That was just the original kind of inspiration for, how would you operationalize that? And our proposal is, imagine a world where you have kind of 10 fixed seats on the court. 5 of them are, selected by, chosen by, affiliated with in some way kind of the kinds of justices that Democrats would want. 5 of them are kind of reserved for Republicans. And there's many ways this could be operationalized. I mean, in theory, you could imagine a world where it's just operationalized by norms. We have other arrangements in government that are like that. We have independent agencies where you have, a power sharing where there's, always a chair who's the president's party, but then there's 2 other members who are the, 3 members, and then there's 2 other members who are the other party. And there are things like this that's not crazy. And then these 10 would then have to pick 5 more justices drawn from the lower courts that would come sit with them for periods of a year or so. And they'd have to do so by unanimous consent in order to have a quorum on the court. And the idea here is there's going to be some incentive to identify the kind of, straight shooters, not purely ideological judges on the lower court. And, just one thing I want to make clear is part of my goal here is, and this relates back to something Ilya said, which is, yes, we have this really polarized country, and that's the real problem. And I agree with that, but we can't have that happen to our legal culture. For law to work, for there to have a rule of law, it can't be the case that every legal issue has a Democrat answer and a Republican answer. We need to figure out some way.
Come join me with original public meaning, Dan.
Yeah, but it's not going to, it can't, the solution is not going to just be, my side wins, right? So I could just as easily say, come join Democrats. And I'm kind of, try to be a little bit above the fray on some of these interpretive questions, but just go, why don't you go full living constitutionalist? And that's not satisfying. And it's not satisfying to a lot of people. So we need to figure out some way to restore that middle ground. That's kind of the role there, the idea there. The Supreme Court lottery, the other proposal, which Mayor did not pick up, is the idea is you sort of expand the court so that every kind of court of appeals judge, there's, between 100 and 200 court of appeals judges, they all are formerly Supreme Court justices, and they sit in kind of random panels. So any one appointment is not that consequential. You've got a much bigger court. There's not going to be kind of huge swings, and kind of the, one nomination is not going to be this huge thing that kind of our whole political system goes crazy about. because any given justice is not that important. And there's a lot of analogs to that in other countries that have constitutional courts that are quite large and that sit in panels. And so any one kind of constitutional justice is not that important.
Ilya, anything there you wanted to reply to in particular?
I just think it doesn't get rid of the underlying distrust of the court. You'll be counting to, whoever the swing vote is among those 5 so-called neutrals, and that's the whole ball game again. Look, I will say, in terms, objectively speaking, the number of justices is not a political issue. If we were writing on a blank slate, maybe you would want like 19, because each one of 19 seats would be less significant than each one of 9. You'd have fewer 10-9 decisions than 5-4. But how do you get there? There's a transition issue. And even if you wrote some sort of, agreement that it doesn't go into effect for 12 years, 3 presidential terms, once you got close to there, unless this was a constitutional amendment, it couldn't easily be changed. You'd have just another congressional vote to change it for advantage or what have you. I think that sort of thing might have a long-term solution, or some sort of compromise of adding term limits, a constitutional amendment to have term limits plus fix the number at 9. Some sort of compromise like that might pass, but that might make people feel good, which is part of the ballgame, making people more confident in, the integrity of the court. But it wouldn't change, I think, the substance of the rulings and kind of people being disappointed and kind of the left-right, divergence in interpretation. Yeah.
So I want to come back based on that to touch on something Daniel mentioned early in the opening about the fact that in previous centuries, the court wasn't always so controversial. And this is a contestable claim, but at least part of what some people, and I count myself among them, think is going on is the court is in some sense having to settle more controversial questions because Congress is settling fewer of them. So if you agree with that the problem is we have a fever and the only solution is more Congress. Are there reforms we could?
Yes, here's someone from the Cato Institute saying that Congress should have more power, not in the absolute, just rearranging it within the federal government.
Right. So are there particular reforms you might think of that would push some of these political questions back on Congress?
Sure. Abolish the filibuster. Right. That's one of the sources of gridlock. That's one reason why Congress can't get anything done. Is that it's very hard to overcome to obtain a filibuster-proof majority, and it just leads to endless gridlock.
If we do that, we might as well just move to a parliamentary system.
There's arguments for that. One thing that I think is really interesting is there is a lot of examples from other countries, Latin America, that have had presidential systems where they do end up with gridlock.
Yeah.
And the result of gridlock is then you have these strongmen that come in.
Right.
I can solve everything. I can think of
which in our system is the pen and the phone and the tweet governance.
Yeah, exactly. Well, the tweets are off the table now, but I do have some concerns about that, about the structure there. If it's just producing gridlock, I do think that people get very unhappy with that, and I do think I don't know if the court's increasing power is entirely a story about failures of Congress, because there's some things people might want, government to do that the court can't do. The court can kind of tell people what not to do, and it can sometimes tell people what to do, but it's a lot easier for them to say, don't do this, than to actually create some program that people would want or something like that. But I do think that that's maybe part of the story. The court has accumulated prestige at various points, sort of standing up to other branches. I guess I would like to see, I'm actually not a huge judicial review person. I would much rather see a lot of these questions be resolved democratically rather than by the courts.
The National Constitution Center in Philadelphia has had a constitution drafting project, and there are teams of libertarian, progressive, and conservative scholars. I led Team Liberty. That proposed whatever additions, changes, rewrites of the Constitution that they wanted. So I encourage all of you to check that out. In fact, tomorrow, I think at 3:00, we're having another public event that you can, again, go to the website of National Constitution. Sorry to advertise a different event, a different organization while with ISI, but it's, and there you can see these kinds of issues: who's strong on judicial review, who wants more democracy, all these different things. Now I've forgotten the question.
Go ahead, Dan.
Oh, we were that threw me off too.
Oh, right, the Congress.
Yeah.
It's not just Congress that's abdicated its responsibility in a vacuum. The other two branches are complicit in this warping of our governmental system. So the court, for example, has not enforced what's called the Non-Delegation Doctrine. That is, Congress is not supposed to be able to delegate the legislative power to anyone else, be that Joe Schmo down the street, be it another branch, namely the executive. But Congress has gradually allowed, the Supreme Court has allowed Congress to accrete that power and to shift it. And at the same time, it's allowed power to be centralized. So
Chevron deference and whatnot.
I'm sorry?
Chevron deference and whatnot.
That's part of it. Although, a more complicated story, yes, deferring to the executive branch rather than deciding it yourself. But in the first place, I think Congress should be the one deciding those issues and shouldn't be deciding so many issues anyway. I mean, we let Texas be Texas and California be California and Ohio be Ohio, and we'd have a lot less clashes in Washington.
So I just want to say one small thing in response to that, which is that the idea that the solution is going to be getting the court to rigorously enforce the non-delegation doctrine, which is very controversial, I think is hard to square with history, because the last time the court was really doing that, it produced one of the two or three biggest legitimacy crises, probably the greatest legitimacy crisis the court has ever faced. That was, it's in the kind of prompt for this event. That's the FDR court packing plan was prompted by the court sort of standing in the way of the administrative state as the country is sort of coming into the 20th century, and the court was saying, no, you can't do this in various ways. And people weren't happy with that. I mean, and the court packing plan ultimately fails. That sort of further cements this norm that you don't change the court's size. But it wasn't because people were really happy with what the court was doing. And in part, it's because the court ended up sort of backing away from the precipice. And so I don't think driving straight off the cliff is the thing that's going to solve these problems.
So I actually think that I want to dispel some myths. I don't think there was a legitimacy crisis per se. FDR was hugely popular. The Democrats were hugely popular. In 1936, he won all but 2 states, right? As goes Maine, so goes Vermont. That was that election. Democrats had huge supermajorities in both houses. They could have amended the Constitution to do all sorts of things. And, it was popular. His programs generally were popular. Instead, he, said, never mind, let's just ram through things. And, I don't think it's that the court saw the writing on the wall and changed. That whole idea about the switch in time that saved 9 is really a myth. For one thing, Owen Roberts was already shading over to go more to the left. For another, he had made his decision in the case West Coast Hotel that was the seen as the turning point, the linchpin before FDR proposed his court packing scheme. And we saw from the unpopularity of the court packing scheme that it wasn't, if it was so illegitimate that you need deep structural reform. Well, no, it meant that you need a deep, constitutional amendment or something, perhaps. But let's be clear, that was so with that level of popularity. FDR managed to, propose this thing to add 6 justices, 1 for every justice over 70 and a half years old, to help out those old men who couldn't keep up with their work, right? And it was such a spectacular failure. His own vice president campaigned against it. The Chief Justice, not just the Chief Justice, but Louis Brandeis, Justice Brandeis, one of his big progressive advisors, came out against it. And the Democrats ended up losing 80 seats in the House and 8 in the Senate. Still kept comfortable majorities. That was how popular they were going into all this.
Yeah, I think there's a lot that was going on there, and I think that there's a lot of historical disagreement about the switch in time and how to account for that. One thing, though, that I don't think the lesson from that episode is the right thing for the court to do is to sort of create these standoffs and try to eliminate the administrative state, because the court ended up changing, right? Part of what happens is FDR keeps getting reelected. He appoints, I think, something like 8 out of 9 justices of the court, and the court kind of accepts the administrative state.
He packed the court the old-fashioned way, sustained political power. And whereas in 1937, after 5 years, he hadn't appointed anyone. 3 years later, he'd appointed 7 or 8.
Now, I do think there's a couple other things going on there. I mean, first of all, it didn't go the way he wanted it to. It came extremely close. There were a couple, moments where it could have passed and almost did. And I think part of the lesson of the failure is FDR really chose the wrong way to sell it to the public. He basically chose a dishonest way to sell to the public. He said, it's just about, like, as you said, these helping out these old justices, and people didn't buy that. Everyone knew that's not what was going on. And I think that really was part of what was really the kind of nail in the coffin. And, it's hard to know if he had sort of sold it more in terms of values, how that would have gone.
All right. With that, we've got some really good questions piling up. And so just a few minutes ahead of schedule, I want to dig into the questions so that we have plenty of time for you guys to get to those. The first comes from Roy Miller. What about, as a reform, what about electing Supreme Court justices? Or the second part of that is, what about term limits?
Who wants to take that one first?
I'm against electing judges, period. I think I like the federal system where the executive nominates and the Senate confirms. We don't want judges to be so political in terms of, currying favor and stuff like that. So I don't even like the retention elections that Ted Cruz voted.
Yeah, I have some skepticism of elections. I mean, I think that whatever you can say about the current system, it generally does select for sort of qualified legal minds, and I worry that in a world of elections, maybe we get Justice Judy or something like that. It is a feature of many state courts, but at a certain point, you start to wonder, like, if people are voting for justices because they want them to enact certain, interpret the Constitution in a certain way, what's fundamentally different about what they're doing there than when they're voting for legislators because they want them to enact certain legislation? And I do think that maybe this indirect selection process is maybe more consistent with the idea of law as an enterprise that is somewhat separate from politics. In terms of the term limits, I think that I share Ilya's view that there are kind of pluses. There are things that maybe are better about term limits, things that are worse. I do think it would solve the kind of random distribution problem. I mean, we'd be able to look at the court and say, there's 9 justices because, this person was president, for this long and so forth. And it wouldn't be like Trump gets 3, Obama serves for twice as long and gets 2, Jimmy Carter serves for as long as Trump gets 0, those kind of arbitrary swings. But it's still, each appointment matters a lot. Knowing ex ante how many appointments you're going to get maybe makes the court even more of a political a target during elections where people just know, okay, everything is going to turn on this. It's split 5-4 right now. We got to get those 2 more seats. Otherwise it's going to swing 5-4 in the other direction, and so forth. And so I don't know if it solves those problems. I tend to think that it would be an improvement over a system in which people serve for, some of the justices in the court could serve for 40 years. John Roberts was appointed when he was 50. He could be Chief Justice till he's 90. The 3 Trump appointees, I mean, it's realistic to think of them all serving, 35, 40 years. And that strikes me as too much power for one person to have for that length of time, especially given that we've seen a number of justices serve until much later in life than we normally think people should be exercising that degree of power over the entire country.
And it's really a phenomenon of the last half century. I think before 1970, the average tenure was something like 17 to 18 years. And since then, it's been over 26, something like that. So, I mean, it would solve some things. And actually, I like the idea that if you had regular terms and vacancies, meaning every 2 years in a non-election year, you'd have a vacancy, then whenever you're voting for a senator, whenever you're voting for president, it's quite clear. It's not just some abstract, oh, the court might be in the balance, but it's just definite. You're voting for someone who's going to nominate the next 2 or vote on the next 2 or 3 if you're a senator justice. I think that's good to crystallize in the mind of the voter while they're thinking about tax policy and whatever else that this is at play as well. But again, it would take a constitutional amendment, I think.
Great.
There's a scholarly argument that if you make them senior justices and don't cut their pension, that it's okay, but I don't buy that.
I want to get one more of the questions in the Q&A queue going while our students get their camera booted up and get ready to ask some of their questions. As I mentioned at the outset, we have a group of students who have gathered socially distanced in order to view this and be able to ask these 2 thinkers some questions. So while they get that all rolling, there's a great question in the Q&A section on what about reforming the Supreme Court by actually reforming the lower courts. In other words, if part of the problem is that they're making too many controversial decisions, why not instead significantly curtail the appellate jurisdiction of the court, which Congress has the authority to do in order to relieve some of that burden?
I actually think they should be deciding more cases, not fewer, because there's a lot of good circuit splits. That's what you'd end up with. You'd end up with different law in different parts of the country, which is not. It's a good thing. I like the federalism if it's politically agreed upon, but not different. The Constitution means different things in different parts of the country.
Yeah, I think, it's to evaluate the proposal, we'd want to think about, okay, what are the questions on which we'd be sort of shifting jurisdiction from the court to the lower courts? But it does create a real risk. First of all, selecting those issues is going to have sort of a policy implications. You could say, well, I don't want the Supreme Court to hear any abortion cases. And so what does that mean? That means state courts decide them, lower courts decide them. Which way does that push? That might push more towards preserving the laws rather than invalidating them. It depends a lot on the specifics. And it would create this possibility of, these decisions just being pushed down and you have these really disparate splits on really fundamental issues of constitutional law where you cross the state border and the law looks very different. I do think that we should be, thinking about stuff like this, but I'm not sure how to operationalize that in a way that would actually make any of these problems better.
That'll be Dan's next big law review article, just in time for the 2024 primary.
Yeah, I've got to keep cranking these out.
Great. All right. Well, now we are joined by some students from Young Conservatives of Texas, and I see Jordan Clements there. Jordan, take it away with the first question from y'all. You'll have to turn your mic on.
All right. Can y'all hear it? Can y'all hear me? All right. Sounds good. Thank you. Like Kevin said, my name is Jordan Clements. I'm a marketing major here at UT, also the chairman of Young Conservatives of Texas. I want to thank y'all for your time in this amazing debate so far. So my question is, considering how the Supreme Court declined to hear any of the Trump election lawsuits, despite having the necessary supposedly having the necessary 4 to hear the case with 3 Trump appointees and Justice Thomas, who has a very public grudge against President Biden, do y'all see that fact leading to less public pressure to pack the courts to have any sort of court reform?
I think, yeah.
Go ahead, Dan.
So, I do think in one sense, the court has had an opportunity recently to sort of publicly show like there is a difference between law and politics, that we're not just partisans in robes. And, I think that there's quite likely that will be reinforced when the court ultimately rejects, as I expect them to do. And I think as many observers expect them to do, rejects the latest challenge to Obamacare. So I do think that those kind of examples of the court sort of doing things that kind of like are not exactly what you'd predict in terms of just pure partisan politics, they may not cause politicians to change their rhetoric, but it will kind of further take some of the wind out of the sails of reform. And I do think that, for example, Chief Justice Roberts had some very kind of canny votes last spring. He voted to strike down an abortion law in Jude Medical, and I do think the underlying, when the court does stuff like that, it really does kind of change the political dynamics in terms of who's upset, whose ox is being gored, and so forth.
Yeah, I mean these cases were easy because they were all so bad. But if next time a serious case comes along, and in fact, one could argue that Roberts, with his canniness, exacerbated some of the post-election craziness by before Barrett was confirmed, having the court deadlock 4-4 on the one serious election law claim, which was to Pennsylvania's Supreme Court rewriting its own election law. And the question was, is there a federal issue? Can a state Supreme Court go too far in interpreting its own state law, state constitution in certain ways? Does it rise to the level of a federal either due process or Republican form of government or some sort of state legislature being the master of election law? That case is still pending. That is the petition of whether to, I mean, it's not going to affect the election, but obviously, but it's a serious question that does come up. And I think it would be to the benefit of the country going forward to have that issue resolved, so we don't have these late breaking, state changes in the law ahead of contentious elections. But that goes far afield from your question.
All right, thank you. Chanda?
Hi, my name is Alexander Chanda, and I'm a finance and philosophy major at UT. My question goes somewhat in a different direction, given that it seems to me that it might be the structure of the Supreme Court that's actually helping to hold us together in this partisan time. And by that, what I mean is that it seems to me that given the terms of everybody in our government that's an elected official, they're incentivized to think in a very short-term frame of mind. Whereas the Supreme Court, because they're lifetime appointments, are incentivized to think about the very long term of the country. And they're some of the only officials that have that kind of incentive structure. And so when they make decisions, they're thinking about the sort of long-term health of the country and not sort of a short-term decision-making that's going to get them elected in 2, 4, or 6 years. So I'm curious what you think about that point of view.
I like it. I haven't heard that point of view expressed quite that way, but I think I'm going to adopt some of that. So thank you.
Yeah. So I will say that it's really interesting. It's a really interesting way of thinking about the problem. I think that it still raises this question of, is a justice's term or tenure, does it necessarily translate into their perspective? Now, it may be the case that the kind of short time horizons that elected officials have influence their decision-making because they're worried about the next election. But when you talk about maybe a president, right, especially a second-term president, they're not thinking necessarily about what can I do that's just going to last for the next 2 years. They're thinking, what's my legacy? How am I going to be remembered? What are going to people think about me? And so I don't think it's inevitable that just because someone is serving for a limited period of time, that they don't care about the future. I think there's lots of reasons to care about the future. And I think there's also lots of reasons why a justice, maybe they're going to sit on the court for a long time, but you can't necessarily assume that they're that gives them the incentive to do what's in the long-term interest of the country. But it is a really interesting way to think about it. And it's interesting to think about, having kind of a diversity of terms within government. We have some people with life tenure, we have some people with very short terms, and, or maybe a range in between.
It's also another way of expressing the idea of judicial independence, since they don't have to face voters, they don't have to face anybody ever again. That's why it's there. Yeah.
Hi, guys. My name is Samuel Sampson. I'm one of the vice chairmen here at Young Conservatives of Texas. Thanks for a great debate. My question centers around a brief piece of the debate when you guys were discussing whether or not the court reflects the general opinions or sentiments of the populace. And in particular, whether that is even a piece of criteria that should be rightfully considered on the Supreme Court, or rather that is it even important for the court to reflect the whims or sentiments of the ever changing and ever revolutionizing opinions that we see, especially in the modern day, as opposed to something more sturdy that isn't beholden to these kind of political talking points. And so is that a thing at all? And if the court has a higher purpose, say, or greater allegiance to preserving a moral code than mere sentiments or emotions of the populace, doesn't that render the whole point about changing the structure moot? I was just wondering what you guys think about those points.
So I think that's a really interesting question. And so I don't think that it would be good to have the court just always conducting public opinion polls, and that it should just be a reflection of public opinion. That there's lots of instances where we kind of want the court to say, no, this is a sort of more eternal principle, and the fact that there's this temporary majority that enacts this legislation. We need to sort of stick to our kind of original principles. And you can see that in the flag burning cases, where you have a coalition of both liberal and conservative justices coming together and saying, yes, states and Congress have passed these statutes that say flag burning is unconstitutional, but that's really inconsistent with the First Amendment. That said, I do think that maybe descriptively it's true, and maybe normatively it should be true, that we don't want the court to do things that are crazy, that are like way far afield from what the public wants or expects. And if that does happen, we can imagine that there's going to be feedback from that. The court does something that's really, really unpopular. And they tend to not do that. They tend to not do things that are crazily unpopular. It causes a lot of feedback that can be damaging to the court. And I'm not sure that's a bad thing, to have them at least a little aware of, like, maybe that's a little too crazy for us. Let's stay away from that precipice.
I think I agreed with all of that.
Do I get a prize?
We reached consensus.
All right, go ahead, Jackson.
Hi, my name is Jackson. I'm an officer here at YCT, and I'm also a freshman studying finance at UT. So my question is that, like, and I know it requires a constitutional amendment to do this, which would obviously require a bipartisan kind of agreement. That was a good thing to do. But if you could get a constitutional amendment limiting the president to appointing, say, 2 justices per term, saying every president gets 2 justices, no more and like no less, so that that would kind of stabilize things like that. Do you think that'd be a good idea? And do you think there's any way we do get to the point where we can have a constitutional amendment to do that?
So I want to see what you think about this. I think that you could actually do by statute. Because you could just say, whenever there's a new president, there are going to be 2 new seats added, and any other vacancies will not be filled for at least 3 years, right? If any other vacancies arise, and then just is kind of automatic, and then the justices still get life tenure. I'm not sure why you couldn't do that. And this would be kind of like a sort of low key version of court packing, where you're adding seats, but kind of in a balanced way. You could just say, and I think it was Daniel Hemmel, professor at Chicago, sort of threw something like this out on Twitter, which I think is not crazy. We could just sort of say, new president, beginning of a new presidency, new Congress, you get your 2, and then look, if RBG dies right before the election, that just kind of, the vacancy will be filled, will formally open again, with the next presidential term. I don't see any reason why that would be unconstitutional. And I kind of like it, and we could talk about what the right number is, and, but that doesn't strike me as worse than a system where it's kind of random.
Yeah, I don't think that would require a constitutional amendment. That's just a variation on standard court packing, that you would have 2 vacancies every 4 years rather than just all at once. Problem is, and here's where the only thing I've yet seen on which I agree with Bernie Sanders, when during the primaries he was asked about court packing, and I'm not going to do the accent, or the mittens, but he said, if we do that, then the next time the Republicans take power, they're going to add more, and in 50 years we're going to have 87 justices. That's crazy, and I agree, that's crazy. So I mean, it sort of solves the some of the lowers the heat on the politicization of court packing, But at a certain point, you stop having a court and it becomes this judicial legislature.
But if you say you only get 2, you don't have 87, right? You just, you'd have 2, 2, 2, 2, 2 at the court. That would provide sort of a natural, the court would get a little bigger, but it wouldn't get huge, I think, if you did.
Oh, and you're, so maybe I'm misunderstanding. So you get two right off the bat.
And then the door's closed until the next one. Get your 2. And then there's no new vacancies. If there's a new seat, the seat disappears. And then you get your 2, and then
Okay, so you can't get up to 87 because of lifespans, and someone's only going to serve for like 30 years. So instead, once we get up to doing math on the fly, so a 4-year term, 30 years, right? You're going to do it 7 times before they start dying off, or something like that. And there's like a natural equilibrium. And you end up with like, is it 16? Is that what it ends up with mathematically?
I think it's hard to do it mathematically because different people are going to die at different times.
Right.
Probably something like that.
You end up with that number.
Yeah.
Well, there's the other idea for your next law review article. So again,
I need as many of these
2 ideas. So that one plus the lower court one. So yeah.
Thank you.
Thanks, Jackson.
We got one.
All right, I can ask another one real quick while we have some people formulating questions. A lot of new people, so a lot of shy folks here. So this is a question more targeted toward Professor Epps. So in your balanced court plan with the 5 Republicans, 5 Democrats, and the 5 unanimous consent, would the 5 Republicans and Democrats be chosen by party activists, kind of like delegates at national convention, or would they be chosen more by elected officials? Because there can be a discrepancy between the activist Republicans and elected Republicans and vice versa.
Yeah, and this is one part of the paper where we were a little bit sort of more open and slippery. We said there's a lot of different possibilities. I don't think I'd want it to be chosen by activists. I think what I'd want is to figure out some way to make the arrangement as close to the way it currently works as possible, while still maintaining this kind of the balance, right? And so what I'd like is identifying, and Ilya already talked about, there's some appointments clause arguments. I think those are, there's different possibilities there, and room for debate about what's possible and what's not possible. But, what I'd prefer is I'd be totally fine with having, 5 people that look like, Gorsuch, Kavanaugh, Barrett, and then 5 people that look like, Kagan, Sotomayor, whoever's coming next. And so I don't want necessarily dramatically different kind of justices. Like I don't want like super partisan people on either side. And so the question is just what's the best way to operationalize that? The best way and the sort of most obviously constitutional way is to operationalize it through norms. Just say, look, we need to have some kind of a truce. This is how we're going to do it. We're going to have, you get yours, we get ours, and we'll figure out what happens if there's a vacancy at other times.
All right, cool. Thank you. Are there any more questions out here?
Or you could have a requirement that all justices be named Norm or Norma.
All right.
Any more student questions?
We have one. We have another repeat over here.
Sorry. This just came into my mind regarding kind of this greater overall trend that we see in politics that I think has started to manifest itself, albeit perhaps a little bit delayed on the court, which is this relativization of terms. When we say, I think everyone, regardless of their political bias, would say that the court has been assigned to protect truth and constitutionality, but we live in a time where even jurists can't agree on what those terms are. And it seems like if we look at it in that context, the whole shall we pack the court because, one side's definition is getting too much airtime seems to be a little bit downstream of the greater issue. And so is this solution, I guess, to Professor Epps, just kind of that's just how it's going to be, so we need to come up with something new, or is it something else?
So I think it's something else in the sense that I think I share the kind of underlying concern, which is that we really are experiencing these fundamental disagreements about really, really important things. And I'm worried about what that means for legal culture in particular. We can have a politics that's really riven in that way. And, we kind of vote it out and then we just kind of figure out who wins and that's the outcome. But a legal culture where there's just fundamental lack of agreement on sort of basic things, I think really worries me. And the fact that we're not there yet. We're not there yet is part of the reason why the various election challenges that the Trump campaign brought were sort of swiftly dismissed by every court that heard them, including a number of panels with Trump-appointed judges, Trump-appointed Supreme Court justices. It's because we do share this kind of common center where we can agree that's a bad legal argument, that's a good legal argument. And I'm worried that we're seeing this increasing divergence. And I worry about, are we a generation away from just every legal issue is just going to have these purely partisan answers? What does that mean for, this idea of the rule of law? And that really worries me. And so I guess both of my proposals are really about, is there a way we can kind of find this common ground and sort of figure out some way to establish this kind of common legal culture? Because I think the alternatives just aren't going to work. The alternatives of just saying one side saying we capitulate and we give up and we agree with you about everything isn't likely to work.
I mean, federalism is one solution. I mean, you might, Dan, you might say that my non-delegation solution requires one side to capitulate, but federalism means California gets what it wants, Texas gets what it wants. They just can't boss each other around. And so if you living in Virginia want, or if I living in Virginia want you living in Missouri to do something tough, I don't get to do that. So federalism is one thing, and that would require court action as well. But I think, I just go back to, I think the crisis, quote unquote, is overblown, the legal crisis. I mean, we do have low level of social trust. We have political polarization, that's for sure. But the legal crisis, in times in our history, I mean, there's the Civil War, but even forgetting the Civil War, Jacksonian period, the formation of the Republic, the Reconstruction era, the Lochner era, where the industrialization era, giving rise to the progressives, and then World War II. I mean, we've had very contentious periods of judicial churn where there indeed were different schools of opinion, disagreements at the Supreme Court. Again, what's new now is that it's all about identifiable, coherent judicial philosophies that map onto partisan preferences. That's somewhat new. And, mass media making every issue kind of instantly a national one. I suppose that's new. But we have had periods of division and legal division. And even now, as quote unquote bad as it might be now, the Supreme Court still, it's dropped a little bit. It typically unanimous decisions were about half. The last few years, it's been about 40%. But still, that's big. You don't hear about those cases, but there's more agreement than you might think.
While we get to the next question from the students, I want to interlace one that's appropriate from the Q&A queue, and that is there, given all of what Ilya just said, is there any way in which the Supreme Court has actually departed from its proper authority? So if we say there's a crisis, is there some way that it's violated its actual proper authority?
So I think, probably, a lot of people would agree that there is. The problem is that there would be no consensus on which cases it's done that in, right? And it's going to depend a lot on your political priors about whether that's the case. I don't know if there's many people who would say everything the Supreme Court has done is great and didn't sort of transgress, its proper authority. I think if you're conservative, you're likely to point to Roe versus Wade, Obergefell. There's some cases where the court has kind of taken it upon itself to really decide some very contentious social issues in ways that, in my view, are not totally necessary. I mean, there's no particular reason why you need Supreme Court intervention, particularly on Obergefell, where this is being resolved by legislatures, but people go to the court anyways. And if you're if you're liberal, you're going to look at other cases. You're going to look at Shelby County striking down part of the Voting Rights Act, any number of other cases. But it's hard to say like this is the objective answer to that question because it depends so much on values. And I do think that we are in this increasing, Ilya mentions kind of social trust, because we have this divergence in our legal cultures that he mentioned, and I've talked about a little bit, polarized, affiliated with partisan identity. We see this world where each side is assuming the other is acting in bad faith. Right. The conservatives think the liberal justices are acting in bad faith. Liberals think the conservative justices are acting in bad faith when they decide certain things. And, that phenomenon, which is the larger phenomenon that I'm concerned with, I think is worrisome. And I don't know how to fix that.
Ilya?
I agree with what Dan said.
Okay.
Two points for me.
All right. Yeah. We've got another student question.
Yes. I was wondering what you guys thought about whenever justices are being confirmed, if they should be allowed to be asked on how they will rule in potential cases. Because I know that that's not how things work right now, but do you think that that should be something that happens, and why or why not?
So, they can't be forced. What are you going to do? The senators can vote against them if they don't answer questions. On the other hand, let's say that they were more forthcoming. Would that have convinced more of the Democrats to vote for Amy Coney Barrett? No, right? So it's all about the incentives that each player faces in the hearing. I've actually come out against having public confirmation hearings anymore because in the age of the internet, we can read everyone's writings. We know what they're all about. And you can have closed hearings where they do have currently closed hearings to look at FBI reports, financial records, and other sensitive things like that, when they can have serious discussions, not kind of playing for the cameras. But the incentive the nominee faces isn't to answer forthrightly and score debaters' points or give an academic lecture. That's what Robert Bork did. He actually lost votes with his performance. It's not that he was voted down because he was too conservative. He was going in, he faced a bit of an uphill climb, but he lost votes actively during his confirmation hearing because he actually took the time to answer the senators' questions at length. And so we now have the modern playbook, I guess, in place since Ruth Bader Ginsburg, really, in 1991. In 1993, where you talk a lot without saying anything. And the next time this will be tested, we haven't had it since Clarence Thomas in 1991, is a nomination, a confirmation process during a period of divided government. We were almost on the precipice of that, but then Republicans lost the two Georgia runoffs. And so now, presumably, if as expected, Justice Breyer retires this or next year, the Democrats still will have control of the Senate. But we haven't had a Senate of the opposite party of the president taking up a Supreme Court nominee since 1991. Only at that point does the nominee have some incentive to say more or otherwise, do anything other than just, say nothing effectively.
So I think that's all right about the incentives. I do wish that the public kind of demanded a little bit more, that it wasn't kind of a winning strategy to just say nothing, in part because, it is true that, how much is that going to actually help you get votes? But I think that there is a sort of public, educative function to these hearings. And, that was something that disappointed me a little bit about the way the Barrett hearings worked. And disclosure, I was working with one of the Democratic senators on those, but I did think that she was not super forthcoming on about legal questions. And I understand that. I don't want a world where the justice says, okay, I'm going to give you a vote on this and this and this, and we're kind of just know exactly what we're getting. You have to consider the arguments. But I did think that there were instances where, to the extent that someone like Justice Barrett, she's an advocate of originalism, and one of the selling points of that theory is that it gives you answers, right? It gives you these answers. I thought there might have been some issues where she would have been a little bit more willing to say, here's how originalism works there. I can't give you all the answers to the hardest legal questions because I need to have space to consider those. But there's some easier questions where I can kind of give you the answers and kind of illustrate, do the math and sort of show you how originalism, textualism works. And I think that would have been useful to the public. And I think it's unfortunate that we don't get that.
Didn't she do that? She gave. There was plenty of education if you're not a constitutional lawyer and court watcher.
Text of the Constitution, but there were some questions she was asked, and particularly questions that I thought could have been answered without damaging her. That kind of. She was not, she says, well, it could possibly come up. She didn't want to answer them. I thought that she could have.
There are legitimate, to the student, there are legitimate reasons for not answering certain questions. If there's like a live issue that everyone knows is coming to the Supreme Court next year, and you ask how that judge is going to rule, they can't answer that. That's prejudging a case. They're going to have to recuse. You can't do that. But that's not what Dan's talking about.
Thanks. I think there's another question right now.
All right, that will be our last one. We've got time for this one last question.
Hello, my name is Amanda Taylor. I'm a finance major here at the University of Texas, as well as the treasurer for YCT. So my question basically goes with, do you think any of the things we've talked about or that any other people have talked about could actually happen? Because I know tonight here we've talked a lot about it, thrown different ideas around. A lot of other people around the country have done the exact same thing. But there's always a saying of everything, a lot of things sound good in theory, but in practice, it doesn't always work out that way. So do you think we could actually do any of this or like in the near future or something for way down the line?
So, I've proposed a lot of wacky things in my scholarship. And, usually when I'm writing something, I think that's a good idea, but what are the odds this is going to happen? I do think we've seen more interest in kind of wacky ideas when it comes to the Supreme Court than I really would have expected in a short period. And I think the odds are always going to be against any kind of major institutional change of any kind. I think that, keeping things the same, there's just a certain amount of built-in slowness to institutions. But it strikes me as more plausible than it did 2 or 3 years ago by probably an order of magnitude, even if it's not less likely to happen than to happen.
So I think that in the next 4 years, more seats will be added to the lower courts. We haven't had, as the population's grown, as the caseload has grown, we haven't had new circuit judges since 2002, new district judges since 2002, new circuit judges since 1991, I think. So I think that will happen, and it'll be some sort of political compromise where certain ones don't open up for a number of years or something like that. As far as the Supreme Court's concerned, it would take, so first of all, there's a constitutional amendment issue, which is hard, but if each side gets something they really, really want, I suppose might be, with all the political surprises we've seen the last 5 years, it's who knows, right? But the stuff that doesn't need constitutional amendment, it would take getting rid of the legislative filibuster, and that would mean it would take big Democratic gains, I think, in the 2022 midterms. But we'll see. Maybe Dan and I will have the privilege of serving on this Judicial Reform Commission if it forms, and we'll let you know.
Perfect. Thank
All right. Thank you very much, UT students. Those were great and thought-provoking questions. And in fact, I heard the professors say they're going to steal a couple of ideas. So we appreciate y'all being there. I want to give them each time for closing remarks. And so now we'll shift to that. And Professor Epps, how about you go first on that? We'll give Mr. Shapiro the last word.
Yeah, so we've covered a huge amount of territory here. And I think that the thing I've enjoyed about this conversation is, Ilya and I certainly don't agree on everything. And there's many really big things that we don't agree on. But there still is some room for common ground here. I think that we both kind of have identified maybe we see some of the same problems with the current system and maybe with our current sort of polarized culture in general. We have different views on what the solutions are, but I think we're at least working together kind of in good faith to kind of create this center that I think is important for the rule of law. And that's one reason why I really enjoy doing events like this, that kind of cut across ideological divides, because even if we're not going to be able to agree, we can sort of see, where each of us are coming from and try to figure out, is there some way we can kind of bridge this divide in a way that creates a society that everybody can live with, even if, we can't make everybody happy with all the institutional details.
Proposals for court packing and the like aren't about good government. Dan's generally are. He's really trying to solve things. But for the most part, they're about the direction of the court. And that's why progressive forces pull out all the stops against originalist nominees who would enforce limits on federal power. Indeed, all of the big nominee blowups in modern times, since the bipartisan opposition to Justice Abe Fortas's elevation in 1968, which is kind of where I date the modern age of judicial battles too, have come with Republican appointments. The one quasi-exception didn't actually involve any attacks on the nominee, but the rare case of an election year vacancy under divided government. Merrick Garland would have been confirmed had Antonin Scalia died a year earlier, maybe even a few months earlier. Not that any of this is a good thing. If nominations were depoliticized, whether through term limits or any other reforms, or some unpredictable shock that recalibrated those norms, that would likewise depoliticize the exercise of judicial power, both in perception and reality. But as we've discussed, term limits would take a constitutional amendment, and everything else is either unworkable or doesn't actually solve the identified problem. We can't just wave a magic wand and go back to some halcyon age where the issues we faced as a country or the development of the law, the political dynamic were all different. The only lasting solution to what ails our body juridic is to return to the founders' constitution by rebalancing and devolving power so Washington isn't making so many big decisions for the whole country. This is serious stuff. Depoliticizing the judiciary or toning down our confirmations, that's all laudable, but it'll only happen when judges go back to judging rather than bending over backwards to ratifying the constitutional abuses of the other branches. The judiciary needs to once again hold politicians and bureaucrats' feet to the constitutional fire. Both the non-delegation thing, rejecting overly broad legislation of dubious constitutional warrant to curb executive agency overreach, but even more importantly, returning power back to the states and the people while ensuring that majorities on the local level don't invade individual constitutional rights. Ultimately, judicial power is not a means to an end, be that progressive, conservative, or anything else, but an enforcement mechanism for the strictures of a founding document intended just as much to curtail the excesses of democracy as to empower its exercise. In a country ruled by law and not men, the proper response to an unpopular legal decision is to change the law or amend the Constitution. Any other method leads to a sort of judicial abdication and the loss of those very rights and liberties that can only be vindicated through the judicial process, or to government by black-robed philosopher kings. And as Justice Scalia liked to say, why would we choose 9 lawyers for that job? So the reason we have these heated court battles is that the federal government is simply making too many decisions at a national level for such a large, diverse, pluralistic society. There's no more reason that there needs to be one-size-fits-all healthcare, for example, than that zoning laws be uniform in every city. So let federal legislators make the hard calls about truly national issues like defense or actually interstate actual commerce, but let states and localities make most of the decisions that affect our daily lives. As I said, let Texas be Texas and California be California. That's the only way we're going to diffuse tensions in Washington, whether in the halls of Congress or in the marble palace of the highest court in the land. Thanks.
All right. I want to thank once again both Daniel Epps and Ilya Shapiro for giving us your evening, and the students at the University of Texas for their great questions. A special thanks to ISI and the Diana Davis Spencer Foundation for their generous support of this and other activities. And of course, a special thanks to all who attended here virtually. Thank you very much, everyone, and have a good night.